If you're going through a custody and placement battle in Wisconsin, you might think that having the bigger house, the better income, or a more conducive work schedule gives you an automatic edge in the court system. Or maybe you've heard that moms always get custody and that the kids, well, they get to pick where they want to go. You know, some even think that because they spent more time with their children prior to the divorce, that by default, automatically, they get the children after the divorce is over. But here's the truth. In Wisconsin, judges make custody and placement based on one key idea that matters more than everything else. And getting this wrong could really impact your relationship with your children and your future rights as a parent. So in this video, I'll show you exactly what the judges consider when they make decisions on custody and placement of children in their court. And I'll help you build your case using the 7 sacred factors that judges look at when determining issues of custody and placement. Well, hello, my name is Jeff Hughes, and I'm the CEO of Sterling Lawyers. We are the largest family law firm in Wisconsin, which means that we see more cases and more judges than anybody else, and that gives us a treasure trove of data and experience to serve our clients with. So in this video, I'm going to walk you through the one custody principle that rules them all, and the critical distinction between custody and placement. So third and finally, I'm going to walk you through the 7 sacred factors that judges really care about the most when determining placement and custody in Wisconsin. Okay, number 1, the one principle that rules them all in custody and placement is this: the question, what is in the best interest of the child? So that is the standard that all judges in Wisconsin are required to filter their decisions through when it comes to custody and placement of children. What is in the best interest of the child? So you can think of that question as the lens that all judges see the evidence through and see the case through, and that they use when entering their orders around the issue of custody and placement. Okay, so that brings me to my next point. What is the difference between custody and placement? It sounds the same, doesn't it? Custody, placement, that seems kind of the same. In fact, custody even sounds like placement, because custody means you possess something, you hold something, that you have something with you. Well, I wish it were that simple, but that's not how it works in divorce court in Wisconsin. Custody is much different than placement. So custody is actually decision-making. Whenever you hear the word custody, think of decision-making in divorce court. Whenever a party, a parent, has custody of their children, if they have sole custody, that means they have sole decision-making ability for all of the major decisions. Now, the reality is most judges order, in most cases, they order what's called joint custody, meaning the parties have to collaborate together when making major decisions for the children. So major decisions would be, can they get their driver's license? Where they go to church, where they go to school, what non-emergency medical procedures are they going to undergo, things like that. By default, what the law says is that the parties should have joint custody. Unless they can't manage that, then the judge could say, okay, one party gets sole custody. They could do that. So custody is decision-making for children, whereas placement, that's much different. That's where the child lives and stays day by day, night by night, and so forth. That's critical as a parent. That's your time with your child. So think of placement as time, overnights in particular, and think of custody as decision-making. Those are 2 major distinctions, but they are hand in hand when it comes to divorce in Wisconsin on the issues of custody and placement of children. Okay? All right, that distinction is important. All right, that moves me to my third. I call these the sacred 7 factors that judges look at when issuing orders. This helps them determine what is in the best interest of the child. In some ways, even subcategories below that big standard of best interest, these are these 7 areas, domains that judges look at. So I'm going to walk you through each of these, okay? The first of these sacred 7 that judges look at: physical and emotional safety of the child. There's a whole lot that goes into that. There's not enough time on the internet for me to talk about all the different things that go into physical and emotional safety. We get the physical part of that. We intuitively understand that physical safety, but there's also emotional safety. The judges look at that too. Is there emotional abuse going on? Is that child emotionally compromised in some way? The courts underneath that will also look at, has there been a history of domestic abuse, violence of any type of the parents, either toward the other parent or even especially if it's toward the children. That is like a deal breaker there for that parent in that case, that they've harmed that child physically in the past. Has there been abuse that's gone on? So the judges will look at all of those factors. So anything that weighs into that is evidence into that physical or emotional compromised safety, that's major. The courts look at that. They consider that heavily whenever they issue their orders, okay? Because if one of those two is messed up, it's wrong, that certainly is not in the best interest of a child. Okay, that's number one. Number two is the stability and the continuity of that child's life. Now, there's a rhythm, right? And there's a cadence to every child's life. School, home, friends, family, going to bed at a consistent time, having a consistent, stable home life. Those are factors that the judges weigh carefully. The evidence that surrounds those things is totally admissible in court. The judges want and need to hear that because that certainly impacts their decision around the best interest, right? If there's instability in that child's life with school, with home, with the parent relationship, whatever it is, if there's a compromised continuity in that child's life, the courts look at that and they weigh that heavily when issuing orders. All right, that's the second one. The third one is, what is the quality of the relationship between the child and both parents? Now, there's a lot that goes into a quality of relationship. There's a significant amount of factors that weigh into this, between the age of the child, the needs of the child, the parents' personalities, the child's personalities, all that weighs. But as best the court can, they will hear evidence and will look at that case and they will try to determine what's the quality of the relationship between these children or that child and both of these parents. That's the third factor. For the fourth factor here, it's this: each parent's ability to provide for the child's needs. Now, immediately when we hear that, we think financial. That is certainly important. Child support is going to be a factor in every case, right? One way or the other. So that should take care of that part of it. But also, the child has more needs than just financial. They have emotional needs, they have spiritual needs, and the courts look at that. What's the ability of both parents to provide adequately for that child's needs? Fifth, the courts will also consider, assuming, of course, the child is old enough, they will consider the child's preferences. All right. Now, 3-year-olds can't give preferences. 7-year-olds can't give preferences. Once you start getting past that 10, 11, 12, 13 timeframe, depending on the maturity of each child, that's when preferences are weighed. And they're weighed more heavily the older the child gets. So a 17-year-old, even though the law doesn't say when you're 17, you decide who you get to live with, the law doesn't say that. But practically speaking, 17-year-olds are going to determine in a practical way where they're going to live. And the courts will weigh that heavily and probably ultimately give that child what that child prefers or what that child wants. So think of it as the older the child gets, the more heavy the preferences are weighed. I mean, they're preferences, they're not demands, they're not like orders from the child. The court will consider them preferences, and the older they get, the more heavily they're weighed. Okay, number 6, each parent's mental and physical health. When there's mental health issues, those are really, really tough and really hard on children, hard on parents, hard on everybody involved. If there's mental health issues, and certainly if there's physical health issues, which are easier to quantify, the courts will consider all of that when entering their orders. And that's where it gets really tricky and really dicey to introduce evidence around mental health, emotional health, but they're factors. They're important. The judges look at them. They heavily consider them. Certainly if there's a lot of times it's manifested in substance abuse of some way or the other, courts will certainly weigh that. That's very important stuff for the judges to hear. So the mental and physical health, that's a factor. Big factor. Emotional health too. Okay, 7. The 7th one, the final one, the child's ties to the school and the community and extended family. So extended family, I mean grandparents, cousins, aunts, uncles, all of that sort of stuff rolls up under extended family. So the closer that child has to those ties around school, their friends, their community, less likely the court is going to want to disrupt that. They don't want to change that. They want that child to have that stability that comes from all of those relationships in that child's life. So that's considered heavily. Okay, I went high level here, right? I went all headlines just to give you a sense for how to prepare your case. And I went through the 7 sacred factors that judges actually consider whenever they enter orders around custody and placement. So now that you know this, now that you're aware of those 7 factors, your next big step is to get ready for the guardian ad litem interview. So we have a video right here that talks all about the guardian ad litem and getting prepared for that interview. That first time, that guardian is important to a custody placement case. And it's important for everyone to be prepared for that first interview. I wish you all the best as you work through your case.